Okay, everyone, welcome to the Mighty Ethan Plays Ace Attorney Phoenix Wright Trilogy. Although I do not intend to play the whole thing, I am going to do a Let's Play of the beginning of it. For a little background, I am a actual practicing criminal law attorney. I am a prosecutor in the state of Kansas, so I'm going to see just exactly how accurate this video game is to real criminal cases. So let's start. I have never played an Ace Attorney game before, so I have no idea what to expect beyond the objection memes I see all over the internet. So, let's see, episode 1, the first turnabout. I've also never done a Let's Play before, so this is going to be a new experience for everybody. Ooh, I get an achievement already. Not sure exactly how well a visual novel is going to work for a Let's Play, since there's going to be a lot of reading, obviously, but we'll see how this works. Alright, so there's our murderer, I guess. Reveal that right off the bat. I wonder if I can speed these up. District Court. Hey, that's the correct title for what we have, at least. District Court. We're divided into districts. Alright. Oh. Well, that's not appropriate for court, that outfit. Let's see. Text skip. Screen shake. Is there no speed option? I guess not. Okay. Alright. Well, yeah. Does she mean right off the bat as in I'm a new attorney? Because if so, this is a terrible idea for everyone involved. In fact, in the state of Kansas at least, you are not considered qualified to do certain levels of felony trials until you have had a certain number of lower level felony jury trials. So I'm basically committing malpractice right off the bat here, so that's great. Well, also, you probably don't want to hire your really good friend as an attorney because they're not going to be able to be objective in representing you, at least in something like if it's something easy, like writing a simple contract or something, then that's fine. But like for something like this, you want someone who can look at things objectively without getting wrapped up in it emotionally. Oh. Oh, that's the best kind of client. I'm guilty, tell them I'm guilty. I thought my name was Phoenix. Why is he calling me Nick? Also, as an attorney, you don't go off the newspapers. Alright, yep, dead girl, suspect the boyfriend, that checks out. Oh, well that's great. That is not a good kind of client to have. Now, even though I am a prosecutor, I was a criminal defense attorney for just over 5 years before I came over to prosecution, so I have seen a lot of various different kind of situations, and yeah, the ones who say I'm guilty, I just want to plead, that's honestly, it seems like that would be an easy client to have, but you don't necessarily want that because they might change their mind later if you go along with that, and then come back on you and say, well, you didn't represent me well enough. You definitely don't want the client that everybody knows is a piece of crap who commits crimes all the time, which sounds like this dude is. Okay, see, that's actually realistic. I have definitely known people who, even as a prosecutor, who I prosecute repeatedly, but I like them. They are nice people. They just can't help but do stupid things sometimes. So I can definitely understand that kind of situation. So, and everybody deserves a good defense. That's kind of the whole basis of how our court system is set up. Okay, that's not very nice of the judge. I'm sure that Mr. Wright knows exactly how much pressure he's under. Answer clearly. He is Larry Butts. I'm glad I was paying that much attention. Also, the judge may very well talk to a new attorney like this and say, like, are you really sure that you're equipped to handle this case? But he would do it in chambers, off the record, in private, not in the courtroom upon starting the trial. What is the... Oh, God. I probably don't know this. A good thing that he read the report cover to cover so many times. That's good preparation. Preparation is important. I'm actually nervous because I don't know that I do know the victim's name. It's good that he does seem to have a more experienced attorney here. What? I'm playing with a controller. What the crap button is tab? Yeah, that's a... I have no idea. Oh, here we go. Cindy, that's her name. I brought up the evidence at least. Profiles. Where's the court record? Oh, RB, down there. There we go. So this is what I was looking at. Alright. Alright. Cindy Stone. Oh, only 22. That's sad. Alright, who's the victim? That is Cindy Stone. Okay. What was the cause of death? Being bludgeoned to death. She died because she was hit with a blunt object. I knew that one. I don't think that was a sufficiently thorough investigation to determine that this guy is prepared for a murder trial. Okay, yeah, and that's definitely true. Even if it's not your first trial, a trial is stressful. You are keyed up the whole time because your stupid body thinks you need to fight or flee when neither of those things make sense in the context. So, yeah, it is a nerve-wracking thing. It is exhausting. My brain does not work at the end of a day of trial. Okay, what kind of hearing is this? Are we in trial? Because this is not how this goes. If it's some kind of preliminary proceeding, then maybe the judge is trying to figure out the issues involved, but I'm not even honestly sure what is happening at this point. Generally speaking, the attorneys are not telling anyone any facts of the case. So I don't know what's happening. No. No, that is not right. You can't, no. No. So, in order to get this statue into evidence, I would have to call, as the prosecutor, I'd have to call an officer or the first person on the scene or somebody who found it covered in blood or whatever, but I'd have to have a witness and I would have to say to them, what did you find? And they'd say, well, I done found this statue covered in blood. And so I would say, is this that statue you're referring to? And they would say, well, yes, it is. And then I would say, Your Honor, I would move to admit State's Exhibit 1, or A, depending on how we're doing the numbering. And then you'd have to number it like that, so in the record you can tell what you're talking about. And then the judge would ask the defense, is there any objection? And if the defense didn't object, he would admit it. If they did object, then we would have a little mini hearing on that objection before he decided whether to admit it or not. But we can't, there'd be a witness involved. So, like, an attorney can't just say, oh yeah, here's the thing, I want to put it in evidence. That's not how that works. Okay, oh, she's right there. The evidence is all you have. And me having it here in my little evidence, I don't even know what this evidence box. That makes sense. I, as a defense attorney, would have seen everything the state was planning to present ahead of time. So I would know what the evidence was going to be, generally speaking. Obviously, witnesses can surprise you on the stand, but more or less, I would know what to expect. Okay, here we go. We're calling witnesses now. Are we not doing jury selection? I assume there's a jury. I didn't see a jury. In a murder trial, there would almost certainly be a jury. We would have done jury selection. I can't believe we're skipping that. That's the best part. And then we would have done opening statements to the jury. Each attorney would have explained what the evidence was going to be, what it was going to show, and only then would the prosecution get to its evidence. But yes, the prosecution does go first. Oh, the prosecution calls the defendant. Yeah, they can't do that. You have a thing called the Fifth Amendment in the U.S. Constitution says that a defendant cannot be compelled to give evidence against himself, which has been interpreted quite broadly, that the defendant cannot be forced to give any kind of evidence in their own case whatsoever. They can't call the defendant. They can't try and force the defendant to testify. If the defendant does not testify, they cannot even say anything about that to the jury or the court. They cannot try to use it against the defendant in any way, shape, or form. So yeah, we're already way off the rails here. Also, it's just bad strategy. As an attorney, you never want to call a witness who you don't know what they're going to say, and yeah, you wouldn't know what the defendant was going to say, so you would not call them as a witness. The defense might do it, but that wouldn't be till after the prosecution presented their whole case. Okay. And in a case like this with an innocent victim or innocent defendant, you may well want to have the defendant testify, but yeah, this is not how that would be going. In a civil case, absolutely you can call the other party, but we're not in a civil case, we are in a criminal case. And yes, it is always nerve-wracking when your client gets on the stand, even if you're the one who called them. Because clients, they can be crazy sometimes, and they say weird things that you're not expecting, and they dig themselves into very deep holes, and it is frustrating and nerve-wracking. Although sometimes if they really tank themselves on the stand, then at least you can be like, well, I did what I could, not my fault. Ooh, recent breakup. Okay, so are we star-crossed? They did all die, but none of them killed each other, at least. Oh, so she's ghosting you, buddy. Yeah, that don't look good. Okay, while I understand he's trying to rile up the defendant, you would not want to make your victim, you wouldn't want to talk about their love life in a way that makes them seem maybe promiscuous to a jury, because even though that shouldn't matter in a murder case, jurors are unpredictable, they do weird things for weird reasons, and you don't want to do anything to make them see your victim in a negative light if you can avoid it. Okay, I would already know this. I would have already told the defendant about this. He would not be surprised by this. He might still freak out on the stand because of it, because, as I said, defendants can be crazy, but this would not be a surprise to us. Wait. How did that get into evidence? I missed that. Yeah, again, the prosecution can't just be like, oh, here's the passport, without someone to authenticate it. Like, this could be a fake. You have to have somebody to establish this is her real passport. I mean, it could be something simple like the police saying, yeah, when we found the murder scene, we searched the apartment, and in a fire safe in the bedroom, we found this passport. Like, that would probably be good enough for this kind of a thing. But you would have to, in some way, authenticate that passport. You can't just... This hurts me. Oh my. Yeah, this is not... This is the kind of approach that maybe a defense would take to try and make her look bad. To try and throw up some reasonable doubt, like, hey, maybe it wasn't my guy. Maybe it was one of her other millions of lovers that she had who are not happy with her. Why does it have to be this guy? Oh, so yeah, you're not doing a good job there, Mr. Prosecutor. Mr. Payne. Wait, why are you attacking your own victim? Yeah, no. Okay, thank you. Am I gonna get to object? Because that is a completely inappropriate question. No! That's not how you do that. Yeah, that's what you do. I mean, I don't actually think it's well, yes. Okay, so his opinion now is irrelevant because what would be relevant would be his opinion then. If he's since learned things that changed his opinion, that doesn't matter because that clearly didn't affect the murder. But we're not going about it right. And I would have had... Okay, this is a whole game about objections. I didn't even say objection, which would have actually been appropriate in that case. I would have said, objection, Your Honor, relevance. And the judge would have said, you're right, counsel, that question isn't relevant. Move on. Why is he calling me Nick? Oh god. Okay, and see, this is absolutely realistic. So I object, I get the question thrown out, and the defendant proceeds to answer it anyway. That I can totally see happening. I don't know what kind of courtroom this is. That is not any arrangement in any courtroom I've ever seen before. Okay, and again, that was... Wait, can I see the history? Yeah, that was completely inappropriate for the judge to comment on the evidence like that. The prosecutor saying, I believe the motive is clear. That's inappropriate. Yeah, this is not a stage for argument. That would be for closing argument. It's definitely inappropriate for the judge to comment on it, because that would be swaying the jury. So at this point, Phoenix needs to move for a mistrial immediately. I somehow doubt that's going to happen. Oh, I hope that's not true, because that's going to look real bad for him. Oh god, dude. That you're not helping yourself. Yes, okay. Now Phoenix is... I suspect the game wants me to stop him from answering, but honestly, I don't have any legal basis to do so. This is a perfectly valid question. He went, you know what? I'm an attorney. He gets to answer the question. No, I can't. Okay, so yeah, so you want... As an attorney, you cannot suborn perjury, which means you cannot encourage anyone, any witness to lie on the stand. You cannot call a witness if you know they're going to lie. You cannot ask a question if you know they're going to answer it untruthfully, unless you're doing so for the purpose of establishing that they are lying. So like, if I'm a prosecutor and I think the defendant's lying, I can ask him a question that I know he's going to lie to, and then I can catch him in that lie, and that's okay. But I can't do it in any way that where I'm going to be entering false evidence into the record without correcting that record. So yeah, having him answer and just explain himself if it looks bad is the only real situation. I absolutely, as a defendant, as a defense attorney, when he's being asked by the prosecution, I can't be like indicating how he should be speaking. What? Okay, you can't object to him lying. You can question more, but that's not what an objection is. An objection is like if there's a legal problem with something that's going on. So like you might object to a question, or you might object to an answer if the answer isn't responding to the question. But you can't just object and say he's lying. That's not how that works. Okay, so are we done with my guy, or are we like switching and then we're gonna come back? Okay, and again, you can't be telling people ahead of time what a witness is gonna say. I'm confused. Are those people up on the sides, are they the jury, or are they just like audience? Oh hey, it's the actual murderer. I'm glad we know that. He doesn't look shady at all. Okay. Wait, no. Okay, so he's doing what is called testifying in the form of a narrative. That is not okay at all. The whole US legal system is based around you ask a question, you ask a specific question, you get a specific answer. If you need more, you ask a follow-up question. You cannot just ask someone to just say, tell me what happened, and let them go. Like, that's not acceptable. Now, that actually does go back to the suborning perjury thing. One way that you can do this is if you're a defense attorney and you have a defendant who you know is going to lie on the stand, and that's because the defendant has an absolute constitutional right to testify if he wants to. You cannot stop him. But as an attorney, you are also not allowed to ask a question that results in false information being given to the court. So what you have to do is you have to meet with you have to call the defendant, and then you have to say, Your Honor, if I question the defendant, I will develop a conflict and have to withdraw. And that conflict is between your duty of confidentiality with your client versus your duty of candor to the tribunal, which means you have to tell the court the truth. So you have to say, I will develop a conflict if I ask him questions. May he testify in the form of a narrative, and the judge will say, because that's lawyer code for this dude is going to lie his ass off, so I cannot be the one to ask him questions, and the judge is going to know that, and so his options at that point are say no, at which point you'll have to withdraw, and they'll have to start the whole trial all over again, which he doesn't want to do, or just let the dude testify in the form of a narrative. So that's the one situation where you're going to be doing that. This, as just a random witness, that doesn't fly. Oh no, because I bashed her head in. Quailed in fright. Of course you did. Oh, phone in the apartment wasn't working. That seems like that would be a verifiable piece of information we could check on. I wonder if anyone did that. Okay, so the time, maybe we're gonna have a mysterious alibi come up. So the judge actually could ask a question like that. See, normally you go prosecutor, defense, back and forth like that until everybody's out of questions. But technically it's prosecutor, defense, and then the judge can ask any questions if they want to. And then it goes, so it's technically a circle of all three of them. The judge rarely asks questions, but he can do that. The attorney would not be the one answering it. It would be the victim or the witness. If the witness didn't know, we'd have to get another witness to figure that out. But yeah, the attorney would not. Attorneys make argument, witnesses give testimony. Attorneys cannot testify. If you are testifying as a witness, you cannot be an attorney in that case. Clever. Now, since we're at a trial, if we were at like a pre-trial motion or something, the rules of evidence are a lot more lax, and this kind of thing might fly where the judge is asking questions and then the attorney kind of explains the answer. But since we are apparently at the actual trial, yeah, this is not. That attorney is testifying. Again, in a game that's all about objections, I should be saying, "Objection, Your Honor, counsel is testifying." Counsel cannot testify. Oh, and more evidence that Again, who is authenticating this? We need somebody from the electric company to come be on the stand and say, this is an actual record from our company that accurately reflects our records that there was a blackout on the day in question. Now, actually with this, more likely, since as a defense, I'm almost certainly not going to be questioning whether or not there was really a blackout, the prosecution would have subpoenaed this ahead of time and they would have given me a copy and we would have just agreed that it could be admitted without having to call somebody from the electric company, because that's just a pain for everybody. But there will be something like this. And again, why is none of this being marked as an exhibit? That should be exhibit something or other. Exhibit 5 or E. Oh, cross-examination. That is the correct term. Oh, wait. Do I not even know what that is? Or am I just nervous? Okay. This attitude is funny. As a defense attorney, you never assume your client is innocent. 99% of the time, your client is guilty as sin. Even if they're not guilty of what they're charged with, they're probably guilty of something. That's just the reality. Most of the time, people did the things they're accused of, or at least things reasonably similar to what they're accused of. So the point is not to establish that your client is guilty. The point is to force the state to do its job and prove them guilty beyond a reasonable doubt. Your job as a defense is just to call into doubt the prosecution's case, not to actually assume your client is guilty. It doesn't matter if they're guilty or not, they're still entitled to a defense and a fair trial. So, and witnesses can lie, or they can misremember, or whatever, even if your person's not innocent. So this whole attitude is odd. Okay, yeah, if he's guilty, he still deserves a defense. It doesn't matter. And again, I don't have to prove anything. The prosecution has to prove it. They have to prove beyond a reasonable doubt, meaning a doubt based in reason. Interesting, we're not allowed to define reasonable doubt to the jury. They have to prove it beyond a reasonable doubt. All I have to do is create the idea of reasonable doubt in the jury's head. And if the jury has a reasonable doubt, even if they think the person probably did, I have had juries say to me after trials, we believe the defendant is guilty, we just weren't sure enough to convict them. And that is correct. That is the correct outcome in that kind of situation. That is how our legal system is. So the defense does not have to prove anything. It's the prosecution's job to prove it. The defense is just trying to bring to light any doubts that might exist. Okay. Okay, so I have to compare his testimony to the evidence at hand. There's bound to be a contradiction. Okay. Honestly, even if my guy is innocent, nothing that witness said would necessarily be false. Like, he could have found her dead and could have seen my guy leaving. So I'm not sure why she's so convinced that he's lying or that there's some evidence to prove it, even if he's lying. Most of the time when people lie, I have witnesses that I don't believe all the time. I definitely have witnesses that if they told me the sky was blue, I would go check. So, but that doesn't mean I can prove it, and that definitely does not mean I have the evidence to prove it. Okay, so let's see. What am I supposed to point out the contradictions in his testimony? Door-to-door selling subscriptions. I didn't carry the... Wait, I didn't even look at this before. What is an attorney badge? I've never heard of that. I have one because I am a prosecutor and am technically a law enforcement officer, so I have like a little sheriff-style badge. Never heard of defense counsel having one. But different states do things different way. That might just be a regional thing. I don't know. So she died between 4 and 5. Well, then he could not have found her at 1 o'clock. Okay, statue, victim, arrived home yesterday. Or, well, the day before the murder, anyway. So the power was out, but his timeline doesn't work. Okay. So I keep going. I thought he must be in a hurry. Okay, so I can go back and forth. Okay, thought to call, the power wasn't working. I went to time exactly, it was 11. So I'm gonna present the time of death. Present! No, but I don't object because he's lying. Yes, see. So yes, this is a perfect question. So I say, sir, you testified that you found the building at 1, or the body at 1 p.m. Is that correct? And you say, yes, it was 1 p.m. I'm 100% sure. And I say, and yet, yeah, well, okay. Now the state should be objection. That's argumentative. And I wouldn't phrase it this way, but essentially I'd say, would it surprise you to know that the autopsy report says that the time of death was not until 4 p.m.? How do you explain that? And he would probably say something like, well, I'm not a doctor, I don't know what the autopsy report says, which, you know, fair enough, but I would have made my point to the jury. And again, now I'm arguing. Okay, see, there's a question. Okay. I mean, objection, this is trivial. That is a valid objection. This is not a valid basis for it in this situation. It's not trivial, but that is at least a legal argument. Okay, and again, this actually, yeah, the judge could ask. I mean, he wouldn't ask in the middle of my questioning. He would ask at the end of my questioning. It would be his turn to ask any questions he had. But yes, he could say, why were you so certain? Lies beget more lies. That's actually true. People who lie once but then stick to the lie, it's a hell of a lot harder to prove it than people who change their story when they're caught in a lie. Because if you say one thing and it's not true, and then we say, oh, but that's not true because X, and then you say, oh, well, blah, 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 and you change your story again, and you do that a couple of times, then I can show the jury, look, they keep changing their story. Don't believe a word they say. Whereas if you lie and you stick to it, it's a hell of a lot harder to prove that it's really a lie when I only have like one thing that calls it into question. Because then people can kind of explain it away in their head and be like, well, maybe they just forgot the time. They didn't remember it as clearly as they thought they did or whatever. But if you start changing your story, then people are like, well, they're changing their story, so clearly they're lying. So moral of the story, if you get arrested, don't change your story. That's my story and I'm sticking to it. Okay, and this actually is, again, not exactly the way we'd be doing it, but the prosecution would get a chance for rebuttal questioning. They would ask the witness to explain the discrepancy if they thought they had any reasonable explanation for it. Okay, Objection, Your Honor. The witness is speculating. You can't. That's not admissible evidence. He could say, I heard the time on the TV, but he can't speculate as to why the time on the TV might have been wrong. Wait, I was already cross-examining. Okay, obviously that was a stupid lie. This is a perfect example of what I was saying. So he lied, he got caught in the lie, he changed his story. Now I get to catch him in a lie again, which is that the power was out. Blackout report. If he just stuck to his story, then I would have had my 1 point about the autopsy, but he wouldn't have created more problems for himself. I thought there was investigation involved in this. I mean, I'm fine with this, I'm just confused. I assumed that we would investigate before. Okay, and again, you can't comment on the evidence, Your Honor. Judge, I guess your name is? Okay, that's actually, no, you were doing good. So when you get caught in a lie and someone points out your lie and you say, explain that, and you just say, I don't know. I'm just telling you what I heard. I don't know. Maybe it's, I don't know. You know, I don't know is always a valid answer, especially when you're caught in a lie, because then you're not creating more problems for yourself by getting more lies that you can get caught in. They're all just educational, by the way. Do not lie on the stand, ever. That is a crime. It is a felony in Kansas. Don't do it. But I just get frustrated when people, especially when I was a defense attorney, it was very frustrating to be trying to help someone and they're actively making things worse for themselves while you're trying to help them. It's very frustrating. Okay, and now this. We don't start the testimony over from the beginning. That's not a good use of anyone's time. I saw it. Oh, okay, so you saw it instead of hearing it. There was a table clock, not the TV. There wasn't a voice. Uh-huh. Wait, did you say the killer used the clock? Okay, that would explain how it was still working if it had a frickin' battery, but wouldn't explain why he said he heard it from the TV, you doofus. Hearing the time. And why would you lie about the... I don't even understand. This guy... Although, granted, most criminals aren't that smart. The lies they come up with are pretty stupid. So this actually is fairly realistic. You with your evidence. That statue is a clock? I actually like, see, now he's doing what I said. Like, that's my story and I'm sticking to it. I'm not explaining your, whatever this thing is that you're trying to confuse me with. I said what I said, and that's what I said. Wait, is that true? Because that's horrifically inconvenient. And also, again, the prosecutor testifying can't do that, but I guess I don't have any problems with his testimony. What? Was I supposed to put that together myself? Because I didn't see a way with the court record that I could have called attention to that stuff. Okay, again, argumentative. Stop arguing. Stop badgering the witness. You can't just accuse people. Real courtrooms are much more subdued than this. Sometimes witnesses testifying get heated, but for the most part, attorneys don't. Unless there's a very difficult witness, and then we're still not yelling and screaming. We're just, you can... Exasperated would be the better way to describe the demeanor of the attorney when that happens. Okay, see, I just testified there, I can't do that. But actually, what I should have done is said, you struck her with the clock and that activated the voice and that's how you heard it, isn't it? And then it's technically a question. I would probably get away with that. Even if it got objected to and the objection was sustained, the jury would have heard my argument, which would have been the main point. They don't need, like, it's a rhetorical question, you don't need an answer from the witness. Why does this judge keep commenting on the evidence? He can't say it's intriguing. Oh, now we're talking about conjecture. Now that we actually have like a logical train of thought leading to a conclusion. Not when people are actually speculating about things. Okay, at this point I've won the trial even without whatever dramatic thing's about to happen. Like, if this were real, by the time I tear his testimony apart, so... Because he's the only thing... We have a motive, yeah, with she broke up with me and she's been sleeping around, so... It's a terrible argument on the prosecution's part, but it at least did kind of establish a motive. I'm jealous. So we got a motive, and then this guy's testimony is the only thing that places the defendant at the scene, so now that I've eviscerated him, he has no credibility left. The jury's not convicting this person. I say that. Juries are unpredictable. You never know what they're going to do. Anyone who tells you they can say what a jury's going to do is lying. But it's not very likely. He has no credibility left. Okay, I'd be objecting again to that response. That was not appropriate. For the witness to comment on what sentence the guy should get. Okay. So this would be what's called demonstrative evidence. Now again, you would have to have a witness do it. Well, no, the clock has been admitted into evidence, so yeah, I could just do it. Oh, that was convenient. So, yeah, it's 3 hours slow. That was a dramatic way to do it. You could have just looked at the clock in the courtroom and said, but as you can see, it's 11:25. This clock is 3 hours slow. That's the kind of information that really the lawyer can get in. It's stuff like what today's date is, you know, stuff like that. That's not really particular to any person's knowledge. I would just ask the court to the way I would probably do it is I would have activated the clock, got the 8:25, and then say I'd ask the court to take judicial notice of the fact that it's actually 11:25 and that this clock's 3 hours slow. But at this point, it doesn't. I don't even have to prove that he's guilty. I have completely destroyed him. Huh. That is also realistic when you ask a question and you say, and then the way they start, you're like, oh no. Sometimes it turns out okay though. I had a little girl on the stand, and the defense attorney asked her if anyone had told her what to say in court today, and she said yes. And I said, I was thinking, oh no, what happened? Oh no, my case is ruined. And then so the defense says, who told you what to say? And she says, my daddy. And he says, what did your daddy say? And she said, to tell the truth. Best answer ever. It turned around immediately from an oh no, what's going on to yes, I just won. But yeah, there's a lot of fear sometimes when you don't know what's going to happen. It's okay, I don't have to have a case. The prosecution needs a case. I don't need a case. I just have to show that their case doesn't make any sense. I've done that. I'm not trying to prove that you murdered her. I'm not a prosecutor. And you're not on trial anyway. No. What? I don't... okay, either they're using words wrong in one way, or they're using words wrong in a different way. So, either he's saying, I can't let you indict the... because indict means to charge with a crime. So, either he's saying, I can't let you charge this witness with murder, in which case he's absolutely right. I'm a defense attorney. I can't charge anybody with anything. I can't, but that's irrelevant. Like, I don't have to charge him with anything. Or he's trying to say, I can't let you impeach the witness, which impeaching is when you call into question their testimony. In which case he used the wrong word, and he's still wrong because I don't have to prove that it was. I just have to show that it might have been. I just am calling into question. The state is the one that has to prove what they are trying to assert. All I'm doing is raising questions, and I have raised a hell of a lot of questions about this guy's testimony. It's not going to get thrown out just because I can't prove that this clock was 3 hours off when it is currently, and that matches with the other evidence. Also, that's what's called circumstantial evidence. Circumstantial evidence is perfectly admissible. So we've got a bunch of circumstances. This guy said it was 1. It was actually 4. He was 3 hours off. This clock that he claims is how he knew is also 3 hours, or he said the clock was 3 hours off. That's why he thought this clock that is the murder weapon happens to be 3 hours off. That's all circumstantial evidence, and that's all perfectly admissible. Contrary to a lot of media you'll see, you absolutely can convict people on circumstantial evidence. So despite the fact that it's not my job, I think not only have I created reasonable doubt for my defendant, I think arguably established this guy's guilty beyond a reasonable doubt. But yeah, that's not... I mean, the cross-examination was over anyway. We'd covered everything I needed to cover, but... yeah, people don't like lawyers. Phoenix is just doing his job. That's another thing you see in media, this hostility between prosecution and defense, and I have seen it in some large jurisdictions. It's there, but for the most part, like, everybody knows everybody else just has a job. They're just doing their job. It's part of the system. Everybody's necessary for the system. Nobody has any hard feelings about it. Like, we're just, without defense attorneys, the state could just, like, charge people with whatever they wanted, or whatever they honestly thought they'd done. Like, the state makes mistakes. I make mistakes. Sometimes I charge people based on the evidence because it looks like they're guilty, and then honest exculpatory evidence comes forward, or the defense point something out, and in those cases, I dismiss the case because, like, it's my job not to see someone convicted. That is not my job. My job is to see justice done. And it's not justice to convict a wrong person, or it's not justice to convict someone for something they didn't do. It's not justice to convict something for someone for something more severe than what they did. So the defense's job is to make sure the state proves its case, that the state does its job, and the state's job is to seek justice for everyone, the defendant included. So there's no hard feelings. We don't hate each other. We don't scream at each other. Everybody's, friends is a strong word, but everybody's friendly at least. None of this yelling and screaming, getting mad. This prosecutor is terrible because he's so wrapped up in the case, which can happen. It's easy for it to happen. I'd like to think it doesn't happen to me, but you care about the case, you put a lot of work into it. It's stressful when the evidence isn't coming out the way you thought it would. But ultimately, like, he shouldn't be objecting to me asking relevant questions that go to the heart of the matter, because that's, again, we're trying to see justice done, so we want to know what happened. He should just be objecting if I'm using shady tactics, which so far Mr. Phoenix Wright has not been. There's been a lot of procedural nonsense going on in this, but I haven't done anything unethical, and the prosecution really doesn't have anything to be upset about, other than just being pissed at their witness for being the murderer, but like, not, if I don't go that far, at least being pissed at them for lying. Wait, did I lose the game? Oh, okay. Not like this. Not like this. I don't have to prove jack crap. I've already won! What are they going on about? Why was the clock 3? Okay, am I like... Think of a reason as to why the clock would be 3 hours slow. Because she had just come from abroad. I assumed that wherever she was traveling was to a 3 hours away time zone. From Paris. Wait, I thought we were in the US. Because Paris is a hell of a lot more than 3 hours off. Yeah, passport, United States of... There is no place in the United States that is only 3 hours time difference from Paris. But I'm... I believe... Okay, yeah, there we go. Oh, clever, Mr. Phoenix Wright. You're smarter than I am. Hopefully, if I had had, like, the weeks to prepare for a trial, I would have caught that, and not just 5 minutes while I'm talking to you guys about what's going on. Mr. Did It. That's funny, but that is not appropriate for a courtroom. I can't make that kind of a comment. That's the kind of thing that we would say in private, the attorneys to each other, like in an office when we're just chatting after the trial's over. That is not appropriate for a courtroom, or for the jury, or for the judge, or... Yeah, none of that. Yeah, you've never seen that because that is completely ridiculous and is... I don't want to say never. Never say never. I would not be surprised if that's never happened though. That's not only a formality, that is very important. Although, on it, as I said before, prosecution should have already dismissed this case. That was bad. Common bird. I wouldn't go that far. Home invasion gone wrong. Not sure what defendant lobby means exactly, but that might be something they have in other jurisdictions. Or good job, me, I won. It is very satisfying to win a case. At least if you think that the defendant was actually innocent, which I did in this case. So, yes, that is very gratifying. Okay, this is actually realistic too. Sometimes people... Oh, that's ominous. Which... I mean, that's the kind of comment you get from people sometimes. Not normally when they've been acquitted. But, yeah. You see dark stuff sometimes. It's... Yeah, bad, bad, bad. Not good. Yeah, and that's rough. I mean, his ex, but he might have been a creepy stalker dude, but he's still, like, it's still upsetting for her to be killed. I mean, that's a hard thing to deal with. Yeah, but you don't have boobs, dude. Wait. How the crap did he get the murder weapon? That should still be in evidence. They've got the other guy to prosecute. Yes, exactly. Oh, okay, it's just a duplicate. So, attorneys are not supposed to accept gifts from their clients, especially in criminal cases. In Kansas, what's called contingency fees are illegal. That's where the fee, or you get some kind of consideration or payment or whatever for winning. You can do those in civil cases. You know, you're hiring me to sue somebody to get money out of them. I can agree that I'll get a chunk of whatever money we recover. That's fine. But in a criminal case, those are illegal. Those are unethical. Can't do those. This is probably okay because it's like considered incidental. Like if they, I don't know, brought you a bag of candy for your office or whatever, like it's not considered a substantial part of the payment. But in general, it's a no-no. Oh, Larry. Yeah, she just knew you were a creepy stalker. She probably still had feelings for you. Those kind of relationships are... those are tough for people. You see a lot of that kind of thing. She took the statue with her abroad. Needed a clock when she went to Paris. Why does he keep calling me Nick? Oh, is that short for Phoenix? That's not a very good, or not very, yeah, that's not much of a nickname. In order to believe them, you have to believe in yourself. Not sure what that means exactly. So, that's kind of good advice, but the thing you need to believe in is that everybody has the right to a good defense. If you wrap yourself up in whether your clients are guilty or not, you will go insane. You cannot worry about that. Everybody, even if they did the thing, they still have the right to a defense and to have the state prove their case. As just a check on the state to make sure that we're all safe from the state being able to lock up whoever they want. So yeah, that is the ideal that you need to hold to, that everybody has the right to a good defense, and it's an important part of the functioning of our society, not whether or not any particular person's guilty. Even if they are, they deserve the right to be defended. Okay, that is sexual harassment. She is my boss. That's not okay. Okay, there's some truth too. I'm pretty sure he's not gonna pay us. Yes, on a criminal case, you get that retainer up front. I mean, this guy's a friend. I get he was doing it as kind of a favor. But normally, yeah, as soon as... Because, again, in a civil case, a client owes you money, you can get out. If they won't pay you, you can get out. In a criminal case, no, because they have a right to an attorney. If they get a different attorney, it delays the whole process. The judge isn't going to allow that. No, once you're in a criminal case, you are stuck. So you need to make sure to get that retainer up front, because most of the time, that retainer is all you're going to say. See, either they get acquitted, in which case they don't have a whole heck of a lot of incentive to pay you after the fact because they're done. They're not under threat anymore. Or they get convicted, in which case also they're not happy with you because they got convicted, or they're in prison potentially where they're not really going to pay you. Their probation, they've got a whole lot of other stuff to pay. Yeah, you need to get that up front. You're probably not going to see a dime after the case is over. And I should say, when I was doing criminal defense, most of what I did was court appointed. That means the county was paying me. So for people who can't afford an attorney, that's most of what I did. I did take some private pay, but for the most part, I was defending indigent defendants. So in that case, I didn't have to worry about it. The county was going to pay me. That you don't get paid till afterward. But yeah, if you're doing private pay, you need to get paid up front. Well, that's ominous. Also, the end. So, that was fun. As ridiculous as it was, I had fun. I think I'll keep playing these. But yeah, it was not an accurate depiction of a courtroom in the slightest. But it was fun. I'm glad. So, let me know what you thought. Maybe I will do more of these. Maybe I won't. But I had fun doing this one. So we'll see what the future brings. I want to say thanks to Haley at MinMax. Her little discussion about this on the bonus podcast is what inspired me. So I will maybe see you all later.